Okay, we'll proceed with Edward Brennan and Terrence Brennan versus Ruth HONSBERGER?
HONSBERGER.
HONSBERGER. All right. HONSBERGER.
Thank you, Your Honor. I'd like to reserve 5 minutes.
All right, sir.
This is the second time this court's had an opportunity to review this case. The first was a written opinion in 40 Southern 2nd at 894, where the court found that the black letter law would prevail, that when there's a request for the admission of a lost
What's that
will.
statute number? You got it handy? What's the statute number?
733-702. And if you're going to admit a lost will, the proponent of that will has to prove two things. First off, the execution of the original will, and it goes on to say that they have to prove the specific content of that particular will. And absent proving both of those, the will is not admitted. Now, in Smith versus DuPerry, found at 86 Southern 3rd at 1228, the second DCA, in that case, there was one disinterested person that testified, and she testified that she didn't read the will and she had no knowledge of what was the specific content of the will, and in that case, the court held that that will was not admissible. In this particular case, at the hearing, they had two disinterested persons. One was a Mrs. Lyles, and through a series of questions, specifically asking her, did she read the will? Had she read the will? Had it even been discussed as to what the terms of the will were? And in each instance, she said she had no specific knowledge of what the specific content of the will was. And that was reaffirmed by Ms. Kessinger, who also testified that she had no idea what was inside the will. And that is record number, page number 33 and record number 40, where that is set out. So I would submit that this will was not admissible as a lost or destroyed will because those elements of proof had not been complied with. I'd be happy to answer any questions if you have.
Anybody got any questions? Okay, you got a lot of time on rebuttal, sir.
Thank you, sir.
Thank you.
May it please the court? Good morning. My name is Cassandra Bowie with the law firm of Roby Law Firm. I'm here on behalf of the appellee, Ruth HONSBERGER, and we are asking the court today to affirm the lower court's ruling and find that the May 31st, 2002 will of Edward J. Brennan, Jr. is the last will and testament of the decedent, and that the testimony of the witnesses, Carol Kessinger and Cheryl Lyles, along with the correct copy of the will, is enough to establish the lost will pursuant to Florida statute.
Did Mrs. Kissinger or Ms. Lyles, did they testify about, they knew about the contents of the will?
They did testify that they knew that the decedent signed the will and he signed it in their presence, but they did not specifically testify that they knew the specific contents of the will.
They testified about execution?
They did, yes.
Okay.
And according to the case law in the estate of Caro, which is found at 598 Southern 2nd, 675, which states that that the purpose of a correct copy is not to prove execution of the original, but to prove the content of the original. And that is what the appellee is relying on in Caro, that the correct copy.
How do you interpret this 733-207, particularly the second sentence, and particularly the last part of the second sentence? It requires that the specific content of the will be proven by two disinterested witnesses, or if a correct copy is provided, it shall be proved by one disinterested witness.
Well,
Doesn't that mean that you have to have, if you have a correct copy, then you still have to have one witness on content?
well, according to Caro, we are saying,
Just let's talk about the statute, if you don't mind, just for a minute, all right?
Okay.
What does the statute say?
the statute does say that if you have one disinterested witness and the correct copy, you need one disinterested witness and the correct copy.
But I mean, what the statute means literally is that if the correct copy is a substitute for one of the witnesses on the issue of what was the content of the will, in other words, but you still have to have somebody testify about content, right?
Well, that is our position, that you do not, if you have the correct
I mean,
copy
but
of
that's
the
what
will.
the statute says, right?
The statute does say if a correct copy is provided, it shall be proved by one disinterested witness.
All right, go ahead, you want to talk about some case law, go ahead.
No, well, the case is Caro, where it says that the correct copy is there to prove the content of the will, of the original will, and that's what we're relying on. And that's what we're saying, that the correct copy, the specific content is laid out in the correct copy of the will, which it is proven that the 2002 will was a correct copy of the will, and the specific content was proven based on that based on the 2002 copy. And then the disinterested witness basically came in to say that this was the will of the decedent, that he signed it in their presence, it was notarized in their presence, and this was his intent to leave the property to Ruth HONSBERGER and his gun collection to his brother based on the 2002 will that was the correct copy. We're asking the court to find that the appellee has proven by presenting the correct copy and at least.
You have in your initial brief, you cite or discuss Smith v. DePerry from the 2nd District, Smith versus DePerry?
I don't believe we cited that in our brief. Did we? I'm sorry.
Yeah. Oh, okay.
She's answered.
Right, I'm sorry. You
I'm
took
sorry,
so
no.
little time. Okay. Which is fine. I applaud you for that. But they address that, and it appears to support a plain reading of the statute. I don't see how we could rule your way without conflicting with that case. The case seems right. You don't address it in your answer brief. You want to try to tell us why that case shouldn't apply, or how you would distinguish it, or whether you think we should conflict with it, or how we think we can reach a result without dealing with it that you want us to reach.
I think that you can reach the result in that the correct copy of the will was provided to the court, and the witness did testify regarding the will was brought in by the decedent, Mr. Brennan Jr., and he did sign the will in the presence of the two witnesses, and they testified
But in
that.
Smith, because the witness could not establish or testify to the contents of the will, they said the will should not have been admitted to probate, correct?
Yes.
And those are the facts here, correct? We all know that they are, yeah. Okay.
Yes.
Well, I guess what Judge Lawson is getting at, if we follow Smith, and don't we have to grant the appellant relief here?
If you follow Smith, yes, you do, but we're asking the court not to follow Smith.
Okay, you can do that, and we don't have to follow Smith if you can explain to us, why we shouldn't in logic and reason, so that's what you need to do.
Okay, well, the reason why you should not follow Smith, because it was the intent of the decedent to leave the property to Ruth HONSBERGER. The decedent had two wills, the 2001 will. There was a 2001 will, which he left the property to, his Canadian property, to his daughter, one of his daughters. He left the gun collection to another daughter. Then he left $5,000 to one of his sons, and then left $1, specifically disinheriting the other son, which was Edward Brennan. And then in the 2002 will, he left the property to Ruth Honsberger, who had been a tenant in that property for over 30 years, and he told her that he wanted her to have the property, so he changed his will to leave the property to her. He also left his gun collection to his brother, and there were no provisions made at all for his children. The brother, actually, who is deceased, actually saw a copy, was the one he sent the will to, and actually saw a copy of the will, or had the original will, excuse me, and therefore, but the brother now is deceased, and therefore and he would have been a disinterested witness because he disclaimed his right to the property to inherit under the 2002 will. So we believe that it's the intent of the decedent, Edward Brennan, to leave the property to Ms. Honsberger. However, he only sent her a copy of the will, which is the correct copy of what he intended to do. And therefore, because no family member was here, and if the brothers or the sons knew about the content of the will, they did not come forward, but then they would be an interested party as well, and therefore they could not say what the content of the will, give the specific content of the will also. But we believe that it's the intent, it was the intent of the...
Couldn't you make that argument in any case where you had a copy of the will and had two witnesses who testified that, yeah, that was the decedent's signature, but did not have a witness who could testify to the content of the will? You could always say, well, the decedent's intent was that will be followed.
But here we have a specific copy which proves the content, so, I mean,
right? So you had a specific copy in Smith, and presumably you'd have a specific copy in any case like this where you have a copy, you have witnesses who can say it was signed, but you don't have a single witness who can say that that testify as to what was in the will that the defendant signed. I'm not the defendant, the decedent.
Yes, but I think you all should look closer to the intent of the decedent in this particular case to see exactly what the decedent wanted. And I believe that based on the 2001 will, along with the 2002 will, you can determine what the decedent wanted. The other thing that Judge Law brought out was the fact that the sons or the children had the opportunity to destroy the will if the original will was located in the home of the decedent, because they are the ones who had access to the home prior to or during the time of his illness up until the time of his death. They're the ones who had access to the home to destroy the will if they wanted to destroy the will, if the original was placed or if the original was housed in the decedent's home. So we're asking the court to affirm the lower court's ruling and admit the 2001 will of Edward J. Brennan into probate as the last will and testament of the decedent. Thank you.
Thank you, Kevin. Thank you.
I'll be even briefer than I was before. I believe the rebuttal to the appellee's argument is found in what you've already found, that there's a presumption that if there's a lost or destroyed will, that it has been intended to be revoked. That was Brennan number 1. And I think Brennan number 2 is the Smith case. On clear reading what the statute says, we haven't even gotten in an argument as to whether it's a correct copy or a otherwise copy, because none of the witnesses to the will knew anything about its specific content. So we believe on the face of the statute, Judge Law should be overturned.
All right, thank you.
Thank you.